Welcome aboard your British Airways flight to Brexit land. Our departure is scheduled at 11 p.m. UK time on Friday the 29th of March 2019. Before we set off, please may we remind you to read the safety instructions on the card in the pocket in front of you. This card contains the current British legislation on transfer of ownership. In addition, a brief description of this will be given to you throughout our flight. Furthermore, we must remind you that this is a one-way flight and no refund is available. The UK comprises of one state, 4 countries and 3 jurisdictions: England and Wales, Scotland and Northern Ireland. Whilst the state has a common parliament, executive and Supreme Court, Scotland and Northern Ireland have been granted with devolution. In 1066, the Battle of Hastings introduced the feudal system. This was brought by William the Conqueror and is a system of hierarchy. The lord would grant use rights to a person who in return would render a service, but the owner would remain the monarch. In England and Wales, this is still the case. The main leading concept was and still is duplex dominion. In the 17th century, there was a union between England and Scotland. However, during the 16th century, there was a substantial reception of Roman law in Scotland. Jurists of the Ius Commune were studied and applied in courts. This created a Roman Scots law, making it substantially different from the law of England. For example, land law was feudal, but the law of movable property was Roman. This remained until 2004, where feudalism was abolished in Scotland. In England, law of the land still remains feudal. So whilst these may seem different in many aspects, on practical matters the systems in England and Scotland are sometimes close. For example, the transfer of land is undertaken by ordinary lawyers and no special role is given to notaries. Conveyancing in both countries is relatively informal and relatively cheap. A uniform tax system applies and both have a land registry. In England, later on, equity was introduced. This is based on a judicial assessment of fairness as opposed to a strict and rigid rule of common law. From an equitable point of view, we are inclined to be somewhat lenient with the negotiations with regard to transfer of ownership.
So now it's time to take out your leaflets because you're about to be educated on the transfer of ownership in England. First of all, what is ownership? When we discuss the transfer of property rights, we must address ownership being a primary property right that is absolute. Unlike in the continental systems, we must distinguish the freehold, this concerns immovables, and title, this concerns movables in the United Kingdom. There is no concept of ownership, meaning that there is only entitlement to exclusive possession. When we are transferring property rights, there are differing approaches to transfer systems in all the jurisdictions. We will therefore be discussing the different aspects that are required to transfer ownership. First of all, we will have the avoidance or annulment of the contract. In the United Kingdom, we prefer to use a causal system rather than the abstract system. And the 2 main systems that make up the mixed transfer system in the United Kingdom being both consensual and traditional. So first of all, we will be starting with the transfer systems. As mentioned before, in England, there is a mixed transfer system. This means that different systems apply to movables and movables. There is a consensual transfer system for movables. This is engraved in Section 17, Paragraph 1 of the Sales of Good Acts. This transfer system is based on a solo consenso. This means that reaching consensus about the contract suffices to pass the ownership. There is a traditional transfer system for immovables. This is registered in the Land Registration Act 2002. In this type of transfer, there first must be a transfer of ownership and a real agreement that is known as a separate legal act aimed specifically at the transfer of ownership. When we're talking about avoidance or annulment of a contract, in the United Kingdom we use a causal system. This causal system ensures that there is no valid underlying agreement, there will be no transfer of ownership. This means that there is a direct connection and the validity of the contract has an immediate transfer of ownership. In England, we prefer to use this causal system as it protects the original owner, unlike the abstract system that is aimed at protecting third parties. When we are talking about the transfer of land, we'll be using the Land Registration Act 2002. Our system transfers the title to land by deed, which is an unregistered system, and by registering it in the land register. The register is entitled to examine and access the applicant's title. And the type of registry that England has is positive, meaning that everything must be registered. The registrar is usually a judge who is required to be active. Now, this is contrary to the negative registry preferred in the in other continental jurisdictions, where the registrar is often a civil servant that is passive. We would recommend our active register, as it is clearly more efficient and provides better results. The registration will also have a constitutive effect, meaning that there is no right without registration.
Time for a detour. While you're enjoying our fresh beverages, let's talk about our civil law counterparts, Germany and France. Starting with France. The French approach towards civil law ownership is single, differing from the entitlement that the UK has. France is a causal consensual system. Due to the consent of contract between the parties, ownership is transferred. The sole consensus rule in the French legal system, as well as that exists in the UK, explains that only the consent is necessary for transfer of ownership. This system of France can be said to protect future owners, since no other formalities are needed, which makes it a speedy and efficient transfer system. In case of invalidity of the contract of sale, ownership returns to the seller. Therefore, a retention of title or reservation of ownership clause may be inserted into the contract to avoid any inequality between parties. When we talk about rules on immovables, in France, even oral contracts can do the transfer of immovables. Transfer doesn't require registration. It takes place on the basis of the contract. There is a duty to register, but nevertheless, it does not affect the transfer if we do not do it. Therefore, there is a negative registration system. When we move on to Germany, the approach of Germany towards ownership is single and absolute. Germany is an abstract traditional system. The validity of the transfer of ownership is judged independently from the validity of the contract. Property right of ownership is seen as independent from personal rights. In the case of an invalid contract of sale, the seller cannot revindicate, since the contract does not affect the transfer of ownership, but has personal contractual right based on the principle of unjust enrichment to regain ownership. The buyer then is obligated under this principle to return the object in question to the seller. When we talk about rules on immovables with Germany, it requires an agreement plus a registration. The agreement must be done in a very formal way, concluded in front of notary. Germany requires a positive registration system, just like UK.
Before we land, here's information about where we are. We know some of you will remain heartbroken, but we have to face our current situation with Brexit. The Britons have voted to leave the European Union by almost 52% in favor. Our departure is scheduled at 11 p.m. UK time on Friday 29th of March 2019, as was already mentioned. We agreed on a 21-month transition period to smooth the post-Brexit relations. This period will start on the 29th of March 2019 and end on the 31st of December 2020. This will allow businesses and citizens to prepare themselves for the new post-Brexit rules between the United Kingdom and the European Union. As was also agreed, free movement will continue during this transitory period. And as our Prime Minister mentioned, Brexit is what the British people voted for in the referendum, and consequently, what they wanted. Therefore, we can only go forward with it from now on. Negotiations about Brexit are in process, and although there is still a long way ahead, we are hoping to reach an agreement on future relations related to trade, travel, and security within the next 6 months. We do not want to end things abruptly with the European Union, and that is why we are taking the time required to settle and negotiate our departure. Before you leave, we believe it might be important to remind you why leaving the European Union could benefit our state. There are in fact a few reasons worth mentioning. Firstly, the European Union threatens our British sovereignty. We have always feared that the average European laws infringe on our sovereignty and our legal system, which we defend from centuries of tradition. Secondly, the European Union is strangling the United Kingdom in burdensome regulations, which is again linked with our sovereignty. For example, the Association Européenne de Libre-Échange was made for exchanges and commerce between various states without impeding on their sovereignty or their legal system. It respected their laws, customs, and traditions. This would not be the case if we would be talking about a common European sales law throughout the European Union. Next, the European Union allows too many immigrants. The United Kingdom always welcomed the Commonwealth immigrants and has always been willing to help. But now, with the European Union, too many immigrants are allowed, which strikes a fear in our population of having their job taken by the ladders. And lastly, the European Union entrenches corporate interests and prevents radical reforms, again, by putting everyone on an equal footing with the same legal structure. After all, the United Kingdom is not only trading with the European Union. There are still many different states with which we trade and conclude exchanges as well as transactions. So, what do we want from you? Well, as we are negotiating our way out of the European Union, it comes with no surprise that we would much rather opt out of a common European sales law. In or outside the European Union, such agreement would require a complete change of our private law system, which, especially in the field of property law, is based on a mixed system which has valuable historical roots. There is nothing to harmonize in our field of property law and transfer of ownership.
Thank you for travelling with British Airways, and we hope you've enjoyed your flight.